My name is Audrey Lynn. I'm 29 years old, and I am a real estate attorney at a mid-sized firm in Seattle, Washington. I spend my professional life reading property documents the way other people read the news, quickly, skeptically, and with a trained eye for the specific kind of language people use when they're trying to claim something that isn't theirs. 5 months into my marriage, my mother-in-law looked me directly in the eye across her own dining room table and told me that the apartment my husband and I were living in, an apartment I owned outright, free and clear, before I ever met him, was family property, and that I now owed her $1,500 a month in rent for the privilege of living in my own home. I smiled at her. I want you to understand that the smile was real, not performed, because I already knew something she didn't know yet, and I was about to enjoy watching her find out. Let me take you back to the beginning, because you need the full shape of this family before the ending will make any sense. Before Daniel, I bought my apartment when I was 25. It's a one-bedroom unit in a converted brick building in Capitol Hill, the kind of place that had character and a few real problems: an old boiler, single-pane windows, a layout that made absolutely no sense until you'd lived in it for a month and figured out the logic, and I bought it with money I'd saved through law school and my first 2 years as a junior associate, plus a modest inheritance from my paternal grandmother, who had been the only person in my family who ever told me, flatly, that a woman should own something with her own name on the title before she ever puts anyone else's name on anything. I loved that apartment with the specific, slightly irrational love you develop for the first thing you ever build entirely by yourself. I refinished the kitchen cabinets myself over a series of exhausting weekends. I picked every light fixture. I knew which floorboard near the bedroom door creaked, and where exactly to step to avoid it. I met Daniel Whitfield at a continuing legal education seminar, a deeply unromantic origin story that he liked to tell at parties as though it were charming, and which, honestly, it kind of was, because he made fun of the seminar's terrible coffee in the most disarming way I'd ever heard a stranger make small talk. Daniel was 32, a corporate litigation associate at a different firm downtown, ambitious in a way that read as confident rather than grasping, and this part matters enormously for what comes later. He came from a family with real money. Old Seattle money, the kind built 2 generations back in shipping and timber and quietly converted into commercial real estate holdings that his mother, Patrice Whitfield, managed with the precise, controlling attention of a woman who had spent her entire adult life believing that money was not just resources, but a form of permanent leverage over everyone who touched it. I want to be fair to Daniel here before I get to his mother, because I don't think this is a story about a weak man married to a controlling one. It's more complicated than that, and the complication matters. Daniel was, in most ways, a genuinely good partner. He cooked. He remembered things. He once drove 4 hours round trip on a Tuesday night because I'd mentioned, in passing, that I missed a specific bakery from my hometown, and he came home at midnight with a box of pastries and an exhausted, proud smile, like he'd accomplished something important. I fell in love with him slowly and completely, and I don't regret it. Even now, even with everything that happened afterward. What I want you to understand is that Daniel had one significant flaw, and it was the same flaw that nearly every adult child of a domineering parent has. He had never, not once in 32 years, successfully told his mother no about anything that mattered to her. He'd built an entire adult life, a law degree, a career, an apartment of his own before we met, that looked, on the surface, like complete independence. But every major decision inside that life had Patrice's invisible fingerprints on it somewhere, and Daniel had simply never had to notice that, because Patrice was skilled enough and patient enough to make her influence feel like guidance rather than control. We dated for 18 months before he proposed. I said yes. I want to tell you about the engagement dinner because it's the first moment Patrice's actual nature showed itself to me clearly, even though I didn't yet have the full picture of what I was looking at. The engagement dinner. Patrice hosted the dinner at her house in Laurelhurst, an enormous, immaculate property with a view of Lake Washington that she discussed unprompted, in terms of its appreciation rather than its beauty. There were maybe 20 people there. Daniel's father, Robert, a quiet, mostly absent presence who I came to understand operated almost entirely as Patrice's silent second. Daniel's older sister Felicity, who ran one of the family's property management entities and had inherited, I would later learn, her mother's exact instinct for converting every relationship into a ledger, and a rotating cast of family friends whose specific function at the dinner seemed to be admiring Patrice's house. Patrice toasted us warmly. She said all the right things about welcoming me into the family. And then, about an hour into the evening, while Daniel was across the room talking to his father, she pulled me aside near the kitchen, refilled my wine without asking if I wanted it refilled, and said, in a tone so light and conversational that it took me a full 10 seconds to register what she'd actually said. "Once you two are married, we'll want to talk about housing. Daniel's apartment really isn't suited for a married couple long-term, and I have a unit in one of our buildings that would be much more appropriate. Family rate, of course." I said something non-committal, that we hadn't really discussed housing plans yet, that we'd figured out together, and she smiled and patted my arm and said, Of course. There's plenty of time," in the specific tone of a woman who has already decided the outcome and is simply being polite about the interval before everyone else catches up to her decision. I didn't think much more about it that night. I want to be honest that I filed it under intense mother-in-law, a category I assumed every long-married woman eventually develops some fluency in managing, rather than understanding it as the opening move of something much larger. The wedding and the apartment decision. Daniel and I got married 14 months later, a modest wedding by his family's standards and a genuinely lovely one by mine, at a small venue overlooking the water with about 80 guests. Patrice cried during the ceremony in a way that I, at the time, found touching, and which I have since come to understand was probably real. Patrice's feelings about family were not insincere, exactly. They were simply inseparable from her feelings about control, in a way that made the two impossible to distinguish from the outside, and possibly impossible for her to distinguish from the inside either. The housing question came up seriously about 2 months before the wedding. Daniel raised it over dinner, somewhat awkwardly, clearly having absorbed some version of his mother's framing without fully realizing it. "My mom mentioned the Belltown building again," he said. "The 2-bedroom on the 8th floor is open. She said we could have it at a reduced rate, like $800 a month, which is basically nothing for that building." I asked him, gently, why we needed to consider that option at all when I already owned a perfectly good apartment. He paused in a way that told me he hadn't actually thought through his own answer yet. "I guess I just figured it might be nice to start fresh, in a place that's ours together, instead of just yours." I want to be honest about how that sentence landed, because I think it's an important detail for anyone in a similar situation to recognize. It wasn't malicious. Daniel wasn't trying to strip me of my home. He was repeating, almost word for word, a framing his mother had clearly given him, dressed up as a romantic idea about shared beginnings, without any of us, including Daniel, fully examining where the idea had actually originated or what it was actually accomplishing. I told him I understood the sentiment, but that my apartment was already paid off, that it was a genuinely good space for both of us, and that moving into a rental owned by his mother, even at a reduced rate, felt like trading something I owned outright for something that would always, on some level, belong to her. I asked him directly, did he want to live in my apartment, the one with no rent and no landlord and no strings, or did he want to live in his mother's building? He thought about it for a long moment, and then he said, "Yours. Obviously yours." I don't know why I was even considering the other thing. And for a while, that was that. We moved in together officially after the wedding. I added Daniel to the deed as a joint owner, a decision I made deliberately and without resentment because I believed genuinely in the partnership we were building, and because the apartment had appreciated significantly since I'd bought it, and I wanted him to have real, legal ownership of the home we were building a life inside of together, not just residency in something that remained entirely mine on paper. I want to flag that decision now because it becomes important later in a way that I did not anticipate at the time and that ultimately worked enormously in my favor. There was one piece of paperwork attached to that addition that I want to mention here because Patrice never once asked about it, and her not asking turned out to matter enormously. When you add a spouse to a deed in Washington state, the structure of that addition matters legally, whether it's added as a gift, as tenants in common, as community property, or under several other configurations, each of which carries different rights and different exposure. My attorney's instinct, even toward my own husband, was to be precise rather than sentimental about it. I structured the addition as tenants in common with a specific percentage split reflecting what each of us had actually contributed, 100% of the original purchase from me, and a documented joint contribution towards subsequent renovations and the remaining mortgage payoff, which by then was minimal. I kept every piece of that paperwork in a folder in my home office, the same folder, as it happens, that would end up sitting on Patrice's dining room table 8 months later. The first 5 months. The first few months of marriage were, by most measures, good. We settled into a rhythm. Daniel's career was demanding but manageable. Mine was too. We had dinner with his parents every few weeks, which I found tiring in the specific way that performing politeness for people who make you slightly uneasy is always tiring, but nothing about those dinners, in the early months, rose to the level of alarm. What I noticed, slowly, was a pattern of small comments from Patrice about the apartment. Never accusatory, always wrapped in the same light, conversational tone she'd used at the engagement dinner. "You really did get a wonderful deal on this place, didn't you?" she said once, looking around our living room with an expression I couldn't quite place at the time but later understood as something closer to appraisal than admiration. Another time, "It's funny, I drove past your building the other day and looked up the comps. Units like yours are renting for quite a bit now." I said something polite. I didn't think in either moment that I was being told something important. The thing that should have alerted me sooner, and I say this now with the benefit of hindsight, the same way I'd eventually tell a client to pay closer attention to a pattern they'd dismiss too easily, was a conversation Daniel mentioned, almost in passing, about a month before everything came to a head. He said his mother had asked him, during a lunch the two of them had without me, whether the two of us had discussed a formal arrangement for the apartment yet. "What kind of arrangement?" I asked. "I don't know," Daniel said. I think she meant like financial. I told her we hadn't really thought about it because it's just our apartment. I should have asked more questions in that moment. I didn't, because I genuinely could not yet imagine the shape of what was coming, and because some part of me, the part that had spent 18 months building a relationship with this family and genuinely wanted it to work, kept extending Patrice the benefit of the doubt that her strange, persistent interest in our housing situation was simply an overbearing mother's quirk rather than the early architecture of an actual plan. I want to add one more piece of context here because I think it explains something about why Patrice felt emboldened to make the specific move she eventually made. About 6 weeks before the dinner, Felicity had gone through a divorce, quiet, by Whitfield family standards, but real, and as part of the settlement, her ex-husband had walked away with a meaningful stake in a duplex the two of them had purchased early in their marriage, a property that, according to a comment Felicity made at a different family gathering, had originally been meant to stay in the family. I think Patrice watched that outcome. Watched a piece of property she considered hers by extension slip partially out of her control through something as mundane as a standard marital property division, and decided, somewhere in the weeks that followed, that she was not going to let the same uncertainty exist around my apartment. I think the rent demand wasn't really about money at all. I think it was about reestablishing, formally and on the record, that the apartment belonged to the family's orbit rather than to me individually, before any future complication could put it at risk the way Felicity's duplex had been at risk. I didn't know any of this at the time, of course. I only pieced it together afterward, the way you piece together a client's actual motive once you've already won the case, and have the luxury of understanding why they fought so hard for something that, to an outside observer, looked completely indefensible from the start. The dinner. The dinner where everything surfaced happened on a Sunday evening in the 5th month of our marriage at Patrice and Robert's house in Laurelhurst, the same house where she'd first mentioned the Belltown apartment at our engagement party. It was meant to be an ordinary family dinner. Felicity and her 2 kids were there too, the children occupied for most of the meal with an iPad in the next room, which in retrospect feels like a small mercy, because what followed was not a conversation I would have wanted children present for. We were partway through dessert when Patrice set down her fork, looked at me with the same light, conversational warmth she always used right before saying something devastating, and said, "Audrey, I think it's time we formalize the arrangement for the apartment." I said, "What arrangement?" "Well," she said, "the apartment is family property at this point, isn't it? Daniel's name is on it now." It only makes sense that, going forward, there should be a proper rental arrangement reflecting that $1,500 a month feels fair, given the market and given that it's keeping things, organized within the family structure. I want to walk through exactly what was happening in that sentence, because I think the mechanism matters as much as the moment. Patrice was not claiming the apartment belonged to her, exactly. She was far too careful a strategist for a claim that crude. What she was doing was redefining the apartment's category. Not Audrey's home, which Daniel now co-owns, but family property, a phrase deliberately chosen to suggest some larger, collective entity, the Whitfield family, as an institution that superseded my individual ownership simply because Daniel's name had been added to the deed. And the rent wasn't framed as something she would personally collect. It was framed as an organizational requirement, an administrative necessity for keeping things organized within the family structure. Language lifted directly, I would later realize, from the property management entity Felicity ran, language designed to make an extraordinary overreach sound like routine paperwork. I looked at Daniel. He looked genuinely surprised. This was clearly the first time he was hearing the specific number, $1,500, even if he'd had some vague, unexamined awareness that his mother wanted an arrangement of some kind. He started to say something, some version of, "Mom, I don't think," and Patrice cut him off smoothly, the way I imagined she had cut him off in conversations like this for his entire adult life, and continued speaking directly to me. "I know it might feel unusual," she said, "but you have to understand from our family's perspective that property gets treated a certain way. Felicity and her husband pay rent on their unit too. It's not personal, Audrey. It's just how we do things." Felicity, beside her, nodded along with the calm compliance of someone who had clearly made peace, years earlier, with this exact framework being applied to her own life, and I noted, even in that moment, the small irony that Felicity's marriage, lived entirely inside this framework, had ended in exactly the kind of division of property that Patrice was apparently terrified might happen to mine. I smiled. I want to be honest that the smile in that moment was not yet the full smile of someone who already knows she's won. It was, in that first half-second, simply the smile of a trial attorney recognizing, with a kind of professional clarity, exactly what kind of argument she was looking at. I have read hundreds of documents built on language exactly like Patrice's, vague, institutional-sounding phrases designed to make an aggressive claim feel procedural and inevitable, the legal equivalent of a magician's patter, meant to distract you from the actual mechanics of the trick. Patrice was running on her own family, the verbal version of an adverse possession argument, and she was doing it with the calm, total confidence of a woman who had never once in her life had that kind of argument actually tested. "I appreciate you explaining how the family does things," I said. "But I want to make sure I understand the actual claim here. Are you saying the apartment belongs to the family, meaning you specifically, and that Daniel and I are tenants in it?" "In a manner of speaking, yes," Patrice said. "Daniel's name being on the title is really more of a formality at this stage of his life. The understanding has always been that significant assets stay within the family's broader structure until they're more established." "Whose name is actually on the deed?" I asked. There was a small pause. Felicity answered this one, with the practiced ease of someone who managed exactly this kind of paperwork for a living. "Daniel's name and Audrey's name, currently. But the family's position is that informal family arrangements supersede that until a formal transfer to the family trust happens, which is standard for assets acquired during marriage." I let that sit in the room for a moment because I wanted everyone, Daniel especially, to hear, clearly, exactly what had just been said. Felicity had just described, with total confidence, a legal principle that does not exist. There is no family position that overrides a recorded deed. There is no standard practice in which a married person's individually titled property becomes subject to a parent's informal claim simply because the spouse's name was later added to it. What Felicity had described was not law. It was a story the Whitfield family had been telling itself, successfully, for long enough that nobody inside the family had ever needed to test whether it was actually true, because nobody inside the family, until that Sunday dinner, had ever had the professional standing to immediately recognize that it wasn't. "I think there's been a misunderstanding about how property law actually works," I said. "But before I get into that, I want to ask one more question." Patrice, when you say the apartment is family property, do you mean that literally? As in, do you believe you have an actual legal ownership interest in my apartment? I believe, Patrice said, with a first small flicker of something less than total composure crossing her face, that as Daniel's mother, and given everything our family has provided for the two of you, I have every right to expect that property within this family be managed according to our standards. That's not what I asked, I said gently. I asked if you believe you have a legal ownership interest. Because if you do, I'd genuinely like to understand the basis for that, because I've reviewed the deed. I drafted the most recent recording on it myself, actually, and your name isn't on it anywhere. It never has been. It's never going to be, unless I personally choose to add it, which, as of right now, I have no plans to do. The unraveling. Patrice's face did something I want to describe carefully because it's the kind of detail that's easy to exaggerate in the retelling, and I want to be precise instead. It wasn't dramatic. It wasn't a collapse. It was the specific, controlled tightening of someone who has spent her entire life winning arguments through tone and presumed authority rather than substance, suddenly realizing that the person across from her has substance and has no intention of being managed by tone. I'm not speaking about a legal technicality, she said. I'm speaking about family obligation. I understand the distinction you're drawing, I said. But you open this conversation by demanding $1,500 a month in rent, which is not a request rooted in obligation. It's a financial claim. And financial claims have to be rooted in something real, either a contract or a legal ownership interest or some other enforceable basis. You don't have any of those things. What you have is a story about how your family does things, which you've apparently told successfully enough times that nobody's ever required you to back it up with an actual document. Daniel, beside me, had gone very quiet, and I could see him doing the same kind of recalibration I'd watched happen in countless courtroom moments over the years, the specific look of someone realizing, in real time, that a story they'd absorbed as simply true for their entire life was, on examination, never actually true at all. Daniel, Patrice said, turning to him, her voice sharpening slightly, surely you understand the principle here. This family has always operated a certain way. You've benefited from that your entire life. And this is the moment I want to slow all the way down because it's the moment the entire trajectory of the evening changed, and it had nothing to do with me. Daniel set down his own fork. I remember the specific small sound of it against the plate, and said, in a voice that was quieter than his mother's, but considerably steadier than I expected, Mom, I don't think I do understand the principle. I think I just never asked you to explain it before, because I never had a reason to. Daniel, you're asking my wife to pay you rent on an apartment she bought herself, before she even met me, with her own money, that she let me put my name on because she trusts me, he said. I don't actually know how to explain that to myself in a way that doesn't sound insane when I say it out loud like that. So, I'm not going to try to defend it. I think you need to explain it, or I think you need to drop it. I want to be honest that I had not expected Daniel to say that, not in that specific moment, not with that specific clarity. I had built, over the preceding several minutes, an entire contingency plan for handling this dinner essentially alone, on the assumption that Daniel's lifelong inability to tell his mother no would hold exactly as firmly as it always had. It didn't hold. I think something about hearing the claim stated out loud, in plain language, stripped of the soft institutional phrasing his mother and sister had wrapped around it for years, finally let him see it the way I'd been seeing it from the very first sentence. Patrice did not concede gracefully. I want to be honest about that too, because I think it's important not to sand down the edges of how badly someone like Patrice handles being told no for what might be the first time in decades. She said several things over the following 10 minutes that ranged from wounded, I have only ever wanted what's best for this family, and I am stunned that my own son would speak to me this way in my own home, to genuinely threatening, in the specific, deniable way that people with resources threaten people who depend on those resources. She mentioned, almost in passing, that the family's continued generosity toward Daniel's career, a reference, I understood, to the substantial introductions and client relationships the Whitfield family had quietly funneled toward his firm over the years, wasn't something that happened in a vacuum and shouldn't be taken for granted by anyone in this room. I did not let that threat pass without naming it directly because I think the entire evening had been, up to that point, a demonstration of exactly how effectively vague, undefined threats had worked on this family for years, and I was not going to let the pattern continue uninterrupted. "Are you saying," I asked, "that if Daniel doesn't agree that I should pay you rent on my own apartment, you're going to retaliate against his career?" "I didn't say that," Patrice said quickly. "You said his continued success shouldn't be taken for granted, immediately after he disagreed with you about the rent," I said. "I'm asking you directly whether that was a threat, because if it was, I'd like us all to be clear about it, rather than letting it sit in the room disguised as something softer." She didn't answer the question directly, which I took, correctly, as an answer. Driving home. We left shortly after that. The drive home was almost entirely silent for the first 10 minutes, the kind of silence that exists not because there's nothing to say, but because there's too much, arriving faster than either person can organize it into sentences. Daniel finally said, somewhere around the I-5 bridge, "I've never seen her back down from anything in my life." "She didn't back down," I said. "She just ran out of road in that specific conversation." "That's different. She'll come back at this from another direction eventually, probably soon, and probably in a way that doesn't involve a direct demand for rent, because she now knows that approach doesn't work on me." "What do you mean, another direction?" I told him what I genuinely believed, based on years of watching how people like Patrice operate once a direct approach fails. I believed she would try, in the coming weeks, to reframe the entire conversation as a relationship problem rather than a legal one, to position me, in conversations with Daniel and with the rest of the family, as someone who had embarrassed her or humiliated her in her own home, shifting the discussion away from the substance of her claim and onto the tone of my response to it. I believed she would enlist Felicity, and possibly Robert, in a slow campaign of social pressure designed to make Daniel feel that maintaining the marriage in its current form was costing him something with his family that he needed to repair by getting me to compromise. I was right about almost all of it, and I want to walk through how it actually played out because I think the slower campaign that followed the dinner is, in some ways, a more useful story than the dinner itself. The campaign. For about 3 weeks after the dinner, Patrice did not mention the apartment again. She called Daniel twice during that period, and both calls, according to what he told me afterward, were focused entirely on how hurt she'd been by the way the conversation had gone. Not by what had been said, specifically, but by the experience of being spoken to that way in her own home, by her own son, in front of her daughter. She kept saying she felt attacked. Daniel told me after the second call. "I tried to point out that nobody attacked her, that she was the one who demanded rent on your apartment, and she just kept circling back to how it felt, not what actually happened." This is, I want to note, an extremely common and extremely effective tactic, and not unique to Patrice. It's the same maneuver I see, professionally, when a party in a contract dispute realizes their actual legal position is weak and pivots entirely to emotional appeals about fairness and feelings, hoping the other side will get so tangled up litigating the emotional register that they forget to keep litigating the actual claim. I told Daniel, calmly, that he was allowed to acknowledge his mother's hurt feelings as real without that acknowledgement requiring him to concede anything about the underlying issue, and that the two things, her feelings and the facts, did not need to be resolved together or traded against each other. About a month after the dinner, the campaign shifted to a second phase, which I'd also more or less predicted. Felicity began inviting me to things: a spa day, a lunch, a girls' shopping trip, none of which we'd ever done together before, all of which had the specific texture of reconnaissance rather than friendship. I went to exactly one of them, the lunch, mostly out of professional curiosity about what she'd actually say once she had me alone. What she said, over salads at a restaurant in Madison Park, was this: "I just want you to know, I don't think Mom was trying to hurt you. I think she's scared. Our family's wealth came from real estate, and real estate is the one thing she's always trusted more than people. I think when she sees an asset sitting outside the family's direct control, especially one as significant as your apartment has become, it's appreciated a lot, since you bought it, she panics a little. It's not really about you specifically. It's about the asset." I want to give Felicity some credit here, because I think this was the most honest thing anyone in the Whitfield family said to me during the entire ordeal, even though she clearly intended it as a softening, persuasive frame rather than an actual confession. She was telling me in plain language that the rent demand had never really been about fairness or family tradition. It had been about control over an appreciating asset that Patrice didn't have her name on, dressed up afterward in whatever language made the underlying motive easiest to swallow. "I appreciate you telling me that," I said. "But I want to be clear about something, since you're clearly here on behalf of your mother. The apartment isn't going into any family trust. It's not becoming family property. I'm not going to be made to feel guilty for owning something outright that I built before I ever met your brother. If your mother wants a relationship with me going forward, it has to start from an acceptance of that fact, not from a slower, gentler version of the same demand." Felicity didn't push back. I think on some level she'd expected that answer, and I think some part of her, the part that had lived through her own divorce and watched her own property get divided in exactly the scenario her mother was now trying desperately to prevent happening to mine, understood that I was simply protecting myself the way she probably wished, in retrospect, she'd protected herself earlier in her own marriage. The legal escalation and why it never actually happened. I want to address something directly here because I think it's the most useful part of the story for anyone listening who finds themselves in a similar situation. I never had to file anything. I never had to go to court. The entire conflict was resolved through documentation and direct, clear communication, not through litigation, and I think that's actually the more important lesson than the satisfying drama of an imagined courtroom showdown. What I did do, about 6 weeks after the original dinner, once it became clear that Patrice's pressure campaign was continuing in its slower, social form rather than actually stopping, was put something in writing. Not a legal filing, a letter, sent by certified mail, on my firm's letterhead, addressed to Patrice directly, with a copy to Daniel and a copy kept in my own files. I drafted it the way I'd draft any communication meant to permanently close down an ambiguous claim before it could escalate further. Calm, factual, completely without emotional language, and devastating specifically because of how little emotional language it contained. The letter stated, in plain terms, the recorded ownership structure of the apartment, my name and Daniel's name, as tenants in common, with a specific percentage split documented in the original deed amendment. It stated that no other party held, or had ever held, any recorded legal interest in the property. It stated that any future communication suggesting otherwise, particularly any communication characterizing the property as family property to third parties, financial institutions, or in any context that could affect its marketability or title clarity, would be treated as a potential basis for legal action, including a claim for slander of title if such characterizations caused demonstrable harm to my ownership interest. I want to explain that last part because it's a piece of property law that almost nobody outside the field has ever heard of, and it was, frankly, the single most useful tool in my entire response to this situation. Slander of title is a real, recognized cause of action. It applies when someone makes false statements about the ownership of a piece of property that damage the owner's ability to sell, mortgage, or otherwise exercise full control over it. If Patrice had, for example, gone to a bank or a title company or even just continued telling extended family and friends, persistently and publicly, that the apartment was family property subject to some informal trust arrangement, and that characterization had ever created confusion or hesitation in a future transaction, a refinance, a sale, anything, I would have had a real, actionable claim against her, not a theoretical one. I did not threaten this dramatically. I included it as a single paragraph, citing the relevant doctrine by name, in a letter that otherwise read more like a routine title clarification than a confrontation. I have found, across years of practicing law, that the most effective way to stop someone who has built their entire approach to conflict around vague, confident-sounding institutional language is to respond with actual, specific, citable institutional language of your own. Patrice had spent months speaking in the voice of someone with legal standing she didn't have. My letter simply demonstrated, calmly, what it actually sounds like when someone says something with real legal standing behind it. The response. Patrice did not respond to the letter directly. She called Daniel the day after it arrived. He told me about the call that evening, and I want to share his account of it because I think it tells you everything about how completely the dynamic between Patrice and me had shifted by that point. She wanted to know if I'd known you were going to send that, he said. I told her I hadn't known specifically, but that I supported it completely once I saw it. She got quiet for a second, and then she asked if I thought our marriage was going to survive this. I told her our marriage was fine. I told her the thing she needed to actually worry about was whether her relationship with us was going to survive, because that part was entirely up to her. I think that phone call, more than the original dinner, and more than my letter, was the actual turning point in this entire story, not because of anything I did, but because Daniel, for what may have been the first time in his adult life, drew a boundary with his mother and held it without immediately backing down under pressure, the way he had every other time something like this had come up before I was in his life. Patrice did not contact me again about the apartment ever. She also did not, for several months, contact either of us much at all, which I understood as a kind of sulking withdrawal rather than genuine reflection, and which I was honestly completely fine with. We attended one obligatory family event during that period, a cousin's graduation party, where she was polite, distant, and clearly still processing the experience of having lost an argument she had never expected to be required to actually win on the merits. Where things are now. It's been 2 years since that dinner. Things with Patrice are better than I expected them to be, though I want to be precise about what better actually means in this context, because I don't think it means what people usually hope it means in stories like this. She has never apologized, not in any direct or complete way. What she has done instead is simply stop. The apartment has never come up again, not once, in 2 years of family dinners and holidays and the ordinary texture of an extended family's life. She has, in her own way, found a version of warmth toward me that exists specifically in the territory she's allowed to occupy, admiring a dinner I cooked, asking genuine questions about my work, the kind of low-stakes generosity that costs her nothing and threatens nothing. I have accepted that version of warmth as real, within its limits, because I think demanding a fuller accounting from someone who is constitutionally incapable of giving one is its own kind of trap, and I'd rather have a workable, bounded relationship with my mother-in-law than spend the rest of my marriage extracting an apology that would mean less to me, in the end, than simply watching her behavior actually change. Daniel changed more than she did, and in ways that have mattered far more to our marriage than anything Patrice ever did or didn't say. He is, 2 years later, a genuinely different person in how he handles his family, not combative, not cold, but clear in a way he simply wasn't before that dinner. He renegotiated, on his own initiative, the terms of some of those client introductions his mother had always treated as leverage, formalizing them through his firm rather than leaving them as informal favors she could theoretically threaten to withdraw. He told me, about a year after everything settled, that the entire experience had taught him something he wished he'd understood 20 years earlier, that his mother's love and his mother's control had always felt, to him, like a single indivisible thing, and that the dinner, and my refusal to accept the premise of her claim, had been the first time in his life he'd actually seen them as two separate things, one of which he could keep while firmly rejecting the other. The apartment, for what it's worth, is still mine. Still ours, legally. Exactly the way the deed has said since the week after our wedding. Daniel and Audrey, tenants in common, no trust, no family arrangement, no rent. We refinanced it last year to fund a kitchen renovation, a transaction that went through cleanly and quickly, with no confusion whatsoever about who actually owned the property being refinanced, which is, I think, the single most boring and most satisfying sentence I have ever gotten to say about my own home. I think about that dinner sometimes, the specific moment Patrice said the words family property, and I felt the smile arrive before I'd even consciously decided to smile. I think about how close the whole situation came to working, not on me but on the family structure around me, the slow, decades-long machinery of vague claims and institutional language that had clearly succeeded, over and over, on people who didn't have the specific professional training to recognize exactly what was happening to them in real time. I got lucky in a sense that my training happened to match exactly the kind of overreach I was facing. But I don't think luck is really the lesson here. I think the lesson is simpler than that and more available to anyone, regardless of what they do for a living. Ownership that's actually documented, actually recorded, actually yours on paper, cannot be redefined by someone else's confident tone, no matter how many times they've successfully used that tone before. The deed doesn't care how the family does things. It only cares what it says, and what it said the entire time was my name. That's my story. One dinner. One demand for rent on an apartment that was never going to be anyone's but mine. And one mother-in-law who learned, in real time, exactly what happens when "that's just how this family does things" finally runs into someone whose entire profession is asking to see it in writing.